All right, more now on our coverage and our breaking news of the Supreme Court ruling on Mifepristone. That continues. Rutgers Reproductive Law professor Kimberly Mutcherson joins us now with more. Kimberly, let's just dive right in here. The justices ruling that Mifepristone can still be available. Your initial take on this?
One, it's pretty interesting to have a unanimous decision on abortion from the U.S. Supreme Court at this point. But also, this is sort of what was expected by a lot of folks. Many of the questions during the oral argument were essentially about the question of standing, which was the question of whether these plaintiffs even had a right to be in court to challenge the FDA on the question of Mifepristone. And that's the way that the court decided to get rid of the case, that these were not folks who actually have a sufficient interest in this issue in order to be able to sue. So it's a pretty big victory for folks who are advocates of abortion rights, and we'll see what happens from here.
So if this came down to a lack of standing and rather not about the merits, do you expect another challenge from another group of plaintiffs that maybe have more of a case for standing in the near future?
Yeah, I mean, I think that a lot of us from the very beginning thought that this case was a terrible one when it came to standing, that it probably would have been kicked on standing in one of the lower courts if it hadn't been brought in the particular, Texas district where it was first brought, and then went up to the Fifth Circuit. So the question will be whether they can find either individuals or organizational plaintiffs who have a closer connection, right? I mean, the issue for these plaintiffs was that none of them perform abortions, none of them prescribe Mifepristone, and they created this very tenuous link between Mifepristone and the work that they do. So if somebody can find a tighter link, then maybe we would see another case.
Well, another major medical case ahead for the justices is Idaho's abortion ban, which prevents doctors in emergency rooms from performing abortions on patients facing dangerous complications. Now, how do you think they're going to rule on that case?
So it's really interesting because in this particular case, the case that I was talking about, the Mifepristone case, one of the standing issues came down to a claim about conscience, that these folks did not want to find themselves in a position where they were forced to provide abortions or to complete an abortion because there was a complication from Mifepristone. And what the court said very clearly here, which echoed what was said by Solicitor General Preliger in the oral argument, was that there are federal protections, there are state protections that say very clearly that people cannot be forced to perform abortions or participate in abortions if their conscience, whether that's their faith or their morality, tells them that they should not be performing abortions. I think we're going to see that come up again in the EMTALA case, where also in the oral argument there were lots of questions about, well, is anyone ever going to be forced to do an abortion? And if not, then the federal government is fine to say that EMTALA actually trumps state law, which should be the case.
It'll be really interesting to see what comes next. Kimberly Mutcherson, thank you very much from Rutgers. We appreciate your insight today.
Thanks for having me.